Howdy. Today I'm going to talk about international laws and specifically General Data Protection Regulation. You need to be aware of this no matter what job you're looking for when you finish this course. The reason is it came out of the European Union. It has been in the press quite a bit. It is targeting large American technology companies. We see privacy on the tipping point of cybersecurity. And I'm not going to go through all the regulations. There's 99 articles in this. Its law went into effect. It was passed in April of 2016. It went into effect in May 25th, 2018. Everyone had at least 2 years notice. As I said, it's 99 articles. It completely has a different philosophy than American privacy laws. And the reason you have to relate this to risk is because it has what's called extraterritorial jurisdiction. That is, the law expands beyond the borders of the European Union. Now, a couple of points. If I ask you what countries were in the European Union, few of us, including me, I would not be able to give you all the countries because they're countries beyond Europe. They're questionably. They're the former Baltic states, Estonia, Lithuania, Latvia. They're all the Scandinavian countries except Norway. Norway has never been in the EU. Switzerland has never been in the EU. Liechtenstein has never been in the EU. So even within the EU, it's a question of who it covers, but the extraterritorial jurisdiction means it covers any entity processing data on an EU citizen or resident. And the courts have yet decided how this is going to work. Now, basically, the history of this is, at one time we had something called safe harbor. Safe harbor is where you go in the storm. And the safe harbor said if you were a European country and you were doing business in the U.S., you'll just come under U.S. laws. Then that was retracted and replaced by the Privacy Shield. And the Privacy Shield was sort of a self-assessment and a registration of being able to do privacy according to EU standards. Well, Europe wasn't happy. They have a different philosophy of privacy because quite a bit was done both by Germany under the Nazi regime and by the Soviets in Eastern Europe by targeting public data. So taking records about the public and using them to target specific groups. So because of this historical perspective, they're a little more sensitive about their privacy. And then Edward Snowden's revelations that the NSA was spying on EU politicians and the like didn't help the matter. So Europeans, to sum this up, view privacy as a fundamental human right. You have a human right to privacy. Do you have a constitutional right to privacy? Well, this is risk. It's not law and policy, but actually, if you were the late Justice Scalia, you would say no. Privacy it's not listed in the Constitution. However, the prevailing rulings of the Supreme Court of the United States now is what's called penumbras of privacy, that your right to privacy is in your First, Fifth, and 14th Amendment rights. We'll sidestep that issue for now. So I put a link here. I won't go to it now, but Tim Cook saying privacy is a human right. And in fact, I've just posted another news article by Tim Cook on coming regulation regarding this. But basically when he says it's a human right, it's a right justifiably believed to belong to every human being. Okay, so here's the key differences between GDPR and current privacy laws. Now, if you were in my law and policy course, I would spend more time. I would go look at the 1974 Privacy Act in the United States, which, by the way, does not define the word privacy. You could do more of a comparison. Here's your key differences. The extraterritorial jurisdiction, which is what I mentioned. The penalties are draconian. The larger of 20 million euros or 4% of your gross sales. So for a company like Facebook, the larger, not the smaller, it's going to be, in the tens of billions. Even for a small company, 20 million euros, approximately think of it as maybe $22, $23 million, is draconian, right? They require consent along every step. So anytime data is taken on you, there has to be explicit consent. You can't opt out by default, you have to opt in explicitly. So in other words, you can't, in the US, we tend to say, if you don't want to do this, opt out. The default here is no, there is no default. You have to explicitly consent. Then you are talked about rights of the data subjects, and data subjects are people, they're you, they're individuals. There's a breach notification, 72 hours breach notification. There is a right for you to access any and all data. There is a right to be forgotten. So you can go to an entity and say, I want everything removed about me. I want all my personal data. So problematic. I'm an attorney in Texas. If you were a client and you came and said, I'm not going to use you as my attorney anymore, destroy all the records on you, I would say I can't, because by my professional ethics and responsibilities to the Texas State Bar, I have to keep the records for so many years as a data retention policy. The right to be forgotten is best exemplified by a court ruling in Europe against Google, where a man posted on the internet revenge porn pictures of his ex-girlfriend. She went to court, she won and prevailed against Google, and Google was ordered by the courts in Europe to forget her, basically, on the internet, remove every single image, nothing can be found about her. So as you can see, this is technically challenging. Then you have data portability, the right that the data subject in this viewpoint owns the data. So I want to move that data, it's my data. The next issue, privacy by design, is problematic. If you're a software developer or do anything that has software or hardware that can be compromised, privacy by design says you have to have the design aspect from the very beginning. And then there's another requirement for data protection officer. If you're a company of a certain size, you have to have a DPO. So here's how GDPR defines personal data. Any information relative to the identified or identified natural person, the data subject, okay, name, identification number, location data, online identifier. Now here's the problematic part. Or to one or more specific factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. So the key question is, can you identify that person by the data? In other words, of all the people out there, what biometric data can I collect on you that I could uniquely identify you? And if that data exists, I have to protect it. Now, here's some issues. There's disagreement on the scope of jurisdiction. I've been to all-day GDPR seminars where two senior lawyers from the same consulting company had completely different viewpoints. There have been no big court decisions yet. There's the issue of what is the EU, but then there's these three countries I mentioned, Norway, Liechtenstein, and Switzerland, that are the EU-A countries, which means they do interface with the EU under certain EU regulations, but by treaty. Then you have the fact that Canada, Mexico, countries in South America, and Singapore are implementing GDPR. And actually, this list is a little out of date because California recently implemented what's called GDPR Lite, focusing on the consumer, focusing on breach notification. So, for instance, breach notification under GDPR is 72 hours. You have 72 hours after you reasonably know a breach has occurred to contact the potential victims of that breach. And then you have this New York law on financial institutions and vendors that has some aspects of GDPR. My point in this is we can't escape it. I was in Europe later this summer, Pottery Barn, the kind of, that's in the malls and online. You can't get to their website from an EU country. It'll come out and say, website's blocked. Basically, we did a business case analysis, we're not doing business there. I went through in several of the websites. I went back and started looking at publications in the U.S., conducted a little experiment. Most of the websites now you'll see come up, we collect cookies. Are you okay with this? You have to accept that's your explicit consent under GDPR. Some of the websites were just blocked. It's like it's illegal to access this website from this country. It's been blocked, not by the government, but by the website owner who doesn't want to mess with GDPR. So they're avoiding the entire risk by not letting their website be accessible in Europe. Now, as I said, if I were going through the Privacy Act, I would show you this. I'll leave you this for your personal edification. I do suggest that if you are interested in this, you sign up for Law and Policy. It's filling up fast in the spring semester. And another aspect of this is that there's two types of companies. The controllers are those that determines the purposes and use and responsible for ensuring that the processors have guarantees, and then you have the processors. So for instance, I'm a big company. I outsource my data processing to Acme LLC. I'm the controller, they're the processor. However, I cannot abdicate my responsibility. I have to ensure that the processors provide sufficient guarantees, the requirements of GDPR. So it's the third-party vendor problem again. And the processors also have to ensure that. So law has been set up so that there is no way that I can pass off my responsibility by contract. I am responsible as a controller. I am responsible as a processor. So what does this have to do with your class? Say, wait a minute, she forgot she's not teaching law and policy? Well, how do we assess risk for privacy violations? How do we assess risk for emerging legislation when we don't have any court decisions and there's not been any fines levied? We are not magicians. We cannot look in the future. We cannot just pull numbers out. And how do we assess risk for losing trust? The Facebook and Cambridge Analytica debacle did not break a federal law, but they did breach trust with their clients, with their consumers. One could argue, well, you were on Facebook, it's free, what did you expect? Doesn't matter when your stock price is falling billions, when you've had the worst day and whatever. Yesterday I was looking at the stock market, all the big technology companies are falling. So I wish I could say to you, here's how you do it. That would be disingenuous. We are on a tipping point for privacy. You are entering a workforce from this course that you are going to have to be cognizant of this. You can say, well, I'm not going to be a cybersecurity. I'm going to be a programmer. I'm going to be doing this or that. Every time you put your hands on the keyboard, you are dealing with personal identifying information, and the privacy laws will get more onerous. So, like I said, I wish I could say this is how you do it. What I will say is keep an eye on what's going on. We have unresolved questions. I read about this every day. There's a belief that U.S. companies are going to be targeted. I believe that. The day it was implemented, there were 100 complaints immediately filed. They are taking on Google, Amazon, Facebook. There's an article I've posted here. I won't take the time from a reliable source, but the GDPR fine still could be months away, so I can't give you any answers. And I posted a reading that it's a belief in Europe anyway that the GDPR fines are not insurable. And as we've seen in data breach cases in the U.S., a lot of times the insurance company will say, no, if you didn't comply, it's not covered in our policy. But what this is saying is in Europe, they are going to make it a law that you cannot recover GDPR fines. In the U.S., there are some statutes. On some insurance, you can't recover some statutory fines. I'm not going to get into that. Let me just say it's another unresolved question. So here's what I want you to take away from this. Keep informed on GDPR. Understand that so much of what I'm trying to teach you in risk assessment right now has no process or methodology. We are learning about risk. I've been at conferences and I've said I'm really frustrated. I'm not sure I know how to teach risk, and I find out from other people teaching it, they feel just the way I do. How do you predict the future, when you don't have historical data? And we'll have another lecture on doing a privacy impact assessment. It's easy to do. You go to the FedRAMP templates, you pick it up, you answer questions. But the best thing I can tell you to do as a practitioner in this field is to learn as much as you can. That's why I'm saying keep informed. Understand the limitations. That's why I'm saying right now we don't have a good process and methodology. And then learn as much as you can on what we have out there and use that to document. Thank you. That concludes this lecture.